warahmatullahi wabarakatuh, and very good morning to our beloved lecturer, Madam Siti Zubaidah. As for today, we are students of Polytechnic Ungkor Oma will presenting to you about our assignment, Chapter 7, which is about winding up, which is our assignment for subject Company Law, DPA 300 Act 3. This group consists of 3 people and we are from Group A. We will introduce ourselves on this slide. Hi, my name is Nur Hizwati Izzah binti Faeng. My matrix number is 01DAT20F1052.
Assalamualaikum to Siti Zubaidah. My name is Nafar Yasmin binti Syaruddin and my matrix number is 01DAT20F1046.
Hello, my name is Anwar Azalila binti Abdul Aziz and my matrix number is 01DAT20F1047.
We will start this presentation by explaining the definition of winding up, followed by the first question about appointment of a liquidator under Companies Act 2016. Then, we will answer the second question about 12 grounds as the circumstances for a compulsory winding up, and we will answer the third question related to problem solving. Finally, we will attach our references at the end of our slides.
Thank you to Izzah. Now I will tell the question of number 1, which is describe the appointment of a liquidator under Companies Act 2016. First of all, what is a liquidator? A liquidator is a professional who handles the affairs of the company under liquidation. The liquidator is given legal authority is to act on behalf of a company in various capacities by courts, by shareholders, or unsecured creditors. Now we look at the answer of this question. There are 5 answers of this question. Firstly is a qualification of a liquidator and the general requirement for the appointment of a liquidator under Section 433, subsection 3 and 4. For Section 433, subsection 3, there's that any person who is a member of a recognized professional body may apply to the minister charged with the responsibility for finance to be approved as a liquidator for the purpose of this act. In Section 433, subsection 4, there's that the minister charged with the responsibility for finance may approve such person as a liquidator if he is satisfied with the experience and capacity of the person, and upon payment of the prescribed fee by such person. Secondly, is an appointment and removal of a liquidator is under Section 445 in subsection 1 and 2. In Section 445 in subsection 1, there's in a member's voluntary winding up, the company shall appoint 1 or more liquidators for the purpose of winding up the company's affairs and distributing its assets in general meeting. In Section 445 in subsection 2, there's 1 the appointment of a liquidator, all the powers of the directors cease except so far as the company in general meeting with consent of the liquidator, or the liquidator sanctions the continuance of all the powers of the directors. Thirdly is an appointment of a liquidators in creditors voluntary winding up is under Section 450. In Section 450, in subsection 1, tells the company shall and the creditors may at their respective meetings nominate a person to be a liquidator for the purpose of winding up the affairs and the distributing the asset of the company. In section 450 subsection 2, if the creditors and the company nominate different person, the person nominated by the creditor should be liquidator, and if no, is nominated by the creditors, the person nominated by the company shall be liquidated. Also in section 450 subsection 3 is notwithstanding subsection 1 and 2, where different persons are nominated, any director, member or creditor may apply to the court for an order directing that the person nominated as liquidator by the company should be the liquidator or jointly with the person nominated by the creditors within 7 days from the date on which the nomination was made by the creditors. Last, in section 450 subsection 7, if a liquidator other than a liquidator appointed by or by the direction of the court dies, resigns or otherwise vacates the office, the creditor may fill the vacancy, and for such purpose meeting of the creditors may be summoned by any two creditors. Then, an appointment or removal of a liquidator by court is under section 453 subsection 1 and 2. In section 453 in subsection 1, where there is no liquidator acting in voluntary winding up, the court may on application appoint a liquidator. Also in section 453 in subsection 2, the court may on cause shown remove a liquidator and appoint another liquidator. Last but not least, an interim of liquidator is under section 440 and 476. In section 440 subsection 1, where the directors of a company have made a statutory declaration that the company cannot by reason of its liabilities continue its business, and the meetings of the company and of its creditor have been summoned for a date within 30 days of the date of the declaration. The director shall forthwith appoint and approve liquidator to be the interim liquidator after the statutory declaration has been lodged with the registrar and with the official receiver. In section 440 subsection 2, an interim liquidator shall have all the functions and powers of liquidator in a creditor's winding up, subject to such limitation and restrictions as may be prescribed by the rules relating to winding up. In section 440 subsection 4 is a notice of the appointment of an interim liquidator. Under this section, together with copy of the declaration lodged with the registrar, should be advertised within 40 days of the appointment of interim liquidator in one widely circulated newspaper in Malaysia in the national language and one widely circulated newspaper in Malaysia in the English language. In section 440 subsection 5, an interim liquidator should be entitled to receive such salary or remuneration by way of percentage or otherwise as is prescribed under the winding up rules. Finally, in section 476 talks about more interim liquidator. In section 476 subsection 1 tells the court may appoint the official receiver or an approved liquidator as an interim liquidator at any time after the presentation of winding up petition and before the making of winding up order. In section 476 subsection 2, the interim liquidator should have and may exercise all the function and powers of liquidator subject to such limitation and restrictions as may be prescribed in the rules or as the court may specify in the order appointing him. Thank you for listening to my answer. Then I will pass to Hizwati to explain the answer for question number 2.
Thank you to Yasmin for explanation for question number 1. Hi, I'm Nur Hizwati Iza binti Paing. I'm going to present the answer for question number 2. There are 12 grounds as the circumstances for compulsory winding up according to section 465, subsection 1, clause A until L. The first is the company pass a special resolution that the company is to be wound up by the court. Next, the company defaults in lodging the statutory declaration. After that, the company does not commence business within a year from the date of incorporation, or the business has been suspended for a whole year. The fourth is there is no member in the company. Let's go through section 465, subsection 1, clause E. In this section says that the inability of the company to pay debts as discussed further in section 466, subsection 1 as follows. First, according to section 466, subsection 1, clause A, the company neglect to pay the indebted sum exceeding 10,000 ringgit after receiving the notice of demand from creditors and the notice period of 21 days has expired. Second, the company fails to satisfy the execution or other process in favor of the creditors. This has been stated in section 466, subsection 1, clause B. Last but not least, is the court is satisfied that the company is unable to pay its debt. This is according to section 466, subsection 1, clause C. The sixth is the directors act for their own interests. Moreover, the company expires as being stated in the Constitution. Besides, the court is in the opinion that it is reasonable that the company be wound up when the substitution or main object of the company is no longer be achieved, of the company is gone. Next, the management is carried on in such a way that the minority is disregarded. Third, there is a deadlock in the management of the company. Last but not least, the company was formed to carry out fraudulent or illegal business. For substratum, minority, deadlock, and illegal business, there are cases of each. I will explain all the cases later. Now, we go to number 9, that is the company license under the Financial Services Act 2013 or the Islamic Financial Services Act 2013 has been revoked. Subsequently, the company has carried on without being duly licensed, or it has accepted, received, or taken deposits in Malaysia in violation of the Financial Service Act 2013 of the Islamic Financial Service Act 2013. Then, the company is being used for unlawful purposes or any prejudicial or is incompatible with peace, welfare, security, public interest, public order, good order, or morality in Malaysia. Lastly, is a declaration has been made by the minister under section 590. As I said on the previous slide, I will explain about the cases for the court opinion. What is reasonable cases that the company be wound up? First is substratum, which is main object of the company no longer be achieved. For example, in the case of Perry versus Stewart. This case about a shipping company lost its only ship. With the remaining asset of £363, minority refused the petition of winding up made by the majority shareholders. In such situation, therefore, it was just and equitable that the company be wound up. Second is case for minority. We can look to case of Ibrahimi versus Westbourne Galleries Limited and others. This case about the company consists two shareholders, Nazar and Ibrahimi, where both of them are the shareholders and directors of the company. They were not paid any dividends but received wages for their services. Later, Nazar's son joins the company as a shareholder and director, and thus father and son control the company. So, they terminate Ibrahimi, which caused him loss of income. Ibrahimi made a petition to wind up the company. It was held that then, when Ibrahimi and Nazar set up the company, it was on the basis that the nature of their relationship, that is, equal partners in the business, would remain the same. Despite the fact what the Nazars did was perfectly legal, it was just and equitable that the company be wound up. After that is about deadlock. The case that related to deadlock is case Yannick Tobacco Company Limited. This case about there are two sole shareholders and both are directors of a company. Later, there were disputes in which communication was no longer met between them but through the secretary. Regardless of this, the company substantial profits. The court decided that mutual confidence had been lost and the company should be wound up. Last but not least is about illegal business. The case that we can refer is the case Prince Med, Thomas Edward and Sons. This case about the company John Prince Med and Sons was a piano maker. However, at the same time, their three employees set up another company to manufacture and sell the pianos. It was then decided by the court that the company was formed with the purpose of committing fraud and should be wound up. That's all from me. I will pass this presentation to Anwar Azalila.
Thank you, Iza, for the explanation for the answer number 2. Now, I will discuss to the answer question number 3. At first, we must know the meaning of winding up. Generally, it is a process in which the existence of a company is brought to an end. There are two types of winding up, which is stated in section 432 subsection 1 of Company Act 2016. First is voluntary winding up and the second is compulsory winding up. Based on the situation given in question 3, we should identify which type of winding up is applicable. Clearly, compulsory winding up is not applicable in this situation because it is a company winding up by court. In contrast, the voluntary winding up ranges of two types, which are members' voluntary winding up and creditors' voluntary winding up. In this situation, Mike and the other shareholders decided to dissolve the company. Besides, the company still be able to pay the remaining debt balance. According to the section 432, subsection 2A, it stated that a warranty winding up may be affected by a resolution by a member's voluntary winding up where the company is solvent and a liquidator is appointed by the members at the members' meeting. As the situation in this question is the company will be wound up by the members and the company is solvent. Hence, it is known as members' voluntary winding up. the creditor's voluntary winding up is applicable to the insolvent company. Now, let us look at the procedures of members' voluntary winding up. Firstly, according to the Section 443 subsection 1, where it is proposed to wind up a company voluntarily, the members which in this situation are MAT and the other shareholders make a written declaration that they have made an inquiry into the company's affair and board of meeting that have formed an opinion that the company is able to pay off their debt in full within a period of not exceeding 12 months after the commencement of winding up. The written declaration is also known as Declaration of Solvency. Next, in accordance with Section 445, subsection 1b, a winding up should commence at the time of the passing of resolution for voluntary winding up. Section 439, subsection 2a specified that the company should submit a copy of the resolution to registrar within 7 days from the passing of the resolution. Subsequently, Section 439, subsection 2b also specified that the company should give notice within 10 days after passing of resolution in one widely circulated newspaper in Malaysia in national language and in one widely circulated newspaper in Malaysia in English language. Then, a liquidator or more than one liquidators should be appointed by MAT and the other shareholders during the members' meeting. Section 445, subsection 1 states that a company should be appoint one or more liquidators for the purpose of winding up the company's affairs and distributing its assets in a general meeting. Moreover, Section 445, subsection 2 also states that on the appointment of a liquidator, all powers of the director cease except with the consent of liquidator in the general meeting or the liquidator sanctions all power of the directors. After the appointment of liquidators, they will take aware of the company's affairs and exercise their powers and duties. According to Section 452, it stated that subject to the provisions relating to the prudential payments under this Act, the property of a company shows on its winding up be a prior inquiry in satisfaction of its liability and show subject to the application be distributed among the members according to their rights and interests in the company, unless the Constitution otherwise provides. In short, the liquidators should realize assets and discharge the company's debt and liabilities if having any remaining balance. It will be distributed among the contributories that is in this situation, MAT and the other shareholders according to their enticement. Eventually, the winding up comes to an end and the company ceases to exist upon to death dissolution of the company. The references that we referred to prepare this presentation, we refers to Companies Act 2016 and Company Law textbook published by Oxford Fajar. That's all from us. Thank you for lending your precious time.